Hi, good afternoon. I'm Tabitha, and this is Katrina, and we're here at the Curry County Annex building. We just got out of a very, very short public hearing related to an RV park development in a very sacred area of Gold Beach, really close to home for Katrina and the Tututni people. We filed an appeal to a decision made by the land use planning director on June 9th within the time frame of an appeal, and a public appeal hearing was scheduled for this afternoon at 1 p.m., at which point some evidence was presented by the planning staff and Board of Commissioners and legal counsel indicating that we did not have standing for this hearing to occur, which is really frustrating because a lot of us have put a lot of time into looking into the Curry County zoning ordinance that would have prevented this action from being permitted in the first place, including riparian buffers. This is an RV park development in a flood zone, and if anyone knows what just happened in Texas, I thought we were smarter than this, but apparently not. It's really disheartening, especially because we were counseled by Curry County staff on the standing to appeal this decision in the first place. And the notice of the application that apparently required standing initially was only sent to a handful of residents. And this obviously affects a lot more than just us. So I'm really quite appalled by the Curry County planning staff and commissioners at this point, and don't understand why we wouldn't be able to speak our voices. About 10 of us were here ready to make public comment on several violations to the county zoning ordinance, and are no longer allowed to say anything.
We also had quite a few comments that were mailed to us by tribal citizens that this is their homeland areas. And they have a lot of concerns with not only the development procedurals, approving the different zones, but also just the fact that this is a highly sensitive area, and tribal consultation, tribal member input, none of that was approached. Like Tabitha said, only a handful of people even knew there was a public comment period open in January. We certainly didn't, and so just feeling very frustrated right now.
Yeah, thank you to everyone who submitted public comment. This won't be the end of the battle.
Yes. We appreciate you all. Thank you.
Are we done, Doc? Well, for those in the audience that are obviously here for a hearing, I had a limited number of copies, but there were some comments that were submitted in the last day. So those are here.
No, she doesn't pick up.
For your review. I think, yeah, we took receipt.
Hey, how's it going?
See them.
Hey, we're gonna try to get Ted in on this same call, so bear with me.
I love a copy.
Yeah.
So you guys might have to share. These are basically your comments that came in the last 24 hours. So
I do have a bet that we have to request for the record to be left open prior to the hearing beginning.
Hey, Ted, I'm merging you in with Jake.
Prior to the hearing actually beginning, yes, but there'll be
Do I have Jake?
the administrative settings of getting the meeting started as first.
And that I could bring that up after.
If it's a
All right, I'm ready when.
Ask me to go start them.
Just give me the thumbs up.
Easter.
Okay, good afternoon, everybody. Today is July 16th. It is 1 p.m. And welcome to this planning meeting in regards to file AP-2502, AD-2431. And I'd like to start with the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so again, this is a planning hearing slash a appeal hearing. Once again, in regards to file AP 2502, AD-2431, and it's regarding an RV park development. So before we get started, I do have to recuse myself from this meeting. I'll run the meeting and conduct the meeting. I'm not allowed to take action, discuss, or vote, as I am a neighbor in this neighborhood, and it is an actual conflict of interest for me to participate in this. So what I would like to do is I would like to turn this over to our county planner, Zach Moody, to give us the staff report.
Thank you. So as you mentioned, this is application for an appeal of file AD 2431 for an RV park located on Wedderburn Loop. The application, the date the notice of appeal was mailed on this application was June 25th, 2025. So hearing date is today. So since the appeal was received, we sent the notice out for public comment. We received notice through today. As a matter of fact, you should all have the last one that was included, which was sent by email at 12:30 this afternoon. There are a number of comments that staff had on the public comments that were submitted, as well as comments provided by the applicant's attorney. And first and foremost, the issue of standing needs to be resolved by the commissioners before the hearing continues. So in your packet, staff's comments provided show that there was a question of whether or not the appellant has standing in the hearing. And as such, the Planning Commission needs to make a determination that they in fact have standing in the appeal process, or the hearing does not continue. So with that, both staff and the applicant's attorney provided the appropriate reference of the Curry County Zoning Code, which states that the applicant must have made comment on the application to make themselves party to an appeal. In this case, the applicant did not provide public comment during the notice period, and such staff believes that the appellant does not have standing in the appeal, and therefore the hearing should be not ordered. So with that, I did cite that information. It's in your additional information. It's also passed out to the public for their review. Specifically, section CCZO 2.0651 states that an administrative permit authorized by the director may be appealed to the Planning Commission pursuant to the following. Who may have appeal? The following persons have standing in the appeal. It's applicant or owner of the subject property, any person who is entitled to written notice of the decision pursuant to this section, and any other person who participated in the proceedings by submitting written comment on the application to the county by the deadline specified in section 2.0635. In regards to any person who is entitled to written notice, since the appellant did not comment on the original application, staff believes that they were not entitled to written notice of the decision. They said that they were not entitled to written notice of the decision. They did not provide public comment on the original application, with their explanation being that they didn't receive a notice. staff has provided in the record where the applicant, or excuse me, the appellant, Diane Howell, did receive notice on January 27th, 2025, and did not provide comment on the application during the public comment period. So with that, staff is asking for the Planning Commission to determine whether or not the appellant has standing in this application, or in this appeal.
Jay or Ted, do you have any comments regarding the staff report and what Zach just covered in regards to the appellate or closing of the hearing?
Well, this is Ted Fitzgerald, and my position is that county code should be followed, and that as described herein, the appellant does not have standing as was communicated.
Jay, did you want to add anything before I jump in?
Yeah, go ahead, Jay.
Is that Commissioner Coker talking?
Yeah, he was just about to get started talking. That's but go ahead.
I'll let him talk. I asked him to actually turn on his microphone because I couldn't hear. Maybe it's not on
Can
yet.
you is your microphone on?
Jay, can you hear me?
I can hear you softly now.
Okay.
I concur with Director Fitzgerald and staff on this in terms of process. Right? If we choose not to follow the process, then we've created an exemption of the process, which now means we need to discuss whether or not we change the process in the future, which I'm not prepared to do. It sounds like the process itself is a sound process and in place to be followed. So I would have to hear a very, very compelling argument as to otherwise why we would forego our own policies in this matter.
Go ahead, Lynn.
So Jay, I'm going to concur with you and with Ted relative to the nature of the policy and the longstanding quality of the policy. I'm not here to change that policy, but I do recognize that there are implications for the people that have attempted to make comments. And having reviewed the comments that have come in so far relative to the process, I don't see a window of opportunity to go forward when it's so clear that the process is what the process is at this point.
So we do have a few public comment cards, and there's Tabitha has her hand up for comment right now. What's the movement for moving forward to public comment?
Commissioner Hollinger, I think the only issue is that we have some process like this, but if the hearing is not open, then we will not be having a meeting, which then would consist of no need for public comment on a non-existent hearing. That's just my take on that portion of the process. But you're running it, so.
Okay.
Well, that would be my position as well as counsel. I mean, if there's nothing, then we don't move forward with an action.
I consulted county staff about this standing issue before going through any of this process. So I think that is, if we're following the zoning code and the ordinances in it, there are several reasons to have this hearing. And I would have appreciated that advice not being a public hearing notice being issued.
Hold on one second. Are you able to hear this at all? I'm sorry.
Yeah, I am. I'm not sure where we're hearing it.
Okay. Well, I can't vote or anything along those lines. So
I think.
is there a, yeah.
We need to call the question for standing.
Has been determined before a public hearing was.
I'm sorry, I can't reply. Okay, then, would someone then like to make a motion?
I would move that we go ahead and deny standing. And is there a particular form which you've got?
No, the code does not prescribe anything except for if the commission votes to deny the standing, the hearing just does not then.
I so move.
Okay, I have a motion from Commissioner Filker. Do I have a second?
Sorry, I was on mute. Yes, second.
Okay, so I will call the question. Commissioner Coker?
Aye.
Commissioner Trost?
Aye.
And I recuse myself. So the motion passes 2-0, and we will close this hearing. The time is 1:12 p.m. and I adjourn. Thank you.
Can I ask a question? Will there be an opportunity to appeal this decision by the BOC and the land use board?
I can't discuss or be any part of this.
Pardon me?
Will there be an opportunity to appeal this decision that the land use board is going to make on this?
So I'd asked about that, and there isn't an alternative for you at this point.
There is no alternative.
Not at this point. There are other downstream actions that I understand that somebody that's concerned about the development can take that are pretty powerful, but at least in terms of these proceedings, you've exhausted the attributes that are available.
How is it that we never received notice? The community at large did not receive notice of the application. So I think there's a fundamental flaw in this code ordinance
So
to hear this
we need to stop.
appeal.
So we had to stop. It can be felt private.
You guys about this issue? Can I request a meeting with the board about this issue?
I've had to abstain from this from the very beginning, so I don't know.
This is not the last step that a community takes in order to do the right thing. But there is a process that's gotten us to this point that leaves you dissatisfied, and I want to understand that.
Well, I would start with the fact that staff
But that's not the point.
acknowledged that we had standing prior to all of us being here right now.
Actually, this is inappropriate. There's no reason to be having this discussion right now.
Why did you schedule this meeting then?
Individually with commissioners, the meeting, right now, the hearing is over, so there's no further public meeting about this that would be appropriate. And by doing so, you are possibly creating a cause of action by the applicant against the county, so I would be very careful in doing that. I would caution against that.
Okay.
Thank you, counsel.
We'll end this. Thank you.